Good morning, students. Today we are going to discuss the American Convention on Human Rights. Okay, so we'll start with the discussion of the drafting history of the convention. Now, the Bogota Charter of the Organization of American States. So the Inter-American Convention is between a convention, between the is a convention between the members of the American states. Okay, that means like USA, Panama, etc. Okay, so the Bogota Charter of the Organization of American States. Okay, this Organization of American States is the in the it's an organization in the same way as we had the Council of Europe. Okay, so this is the executive and political body of the American states. Okay, so the Bogota Charter, okay, it was adopted by the Organization of American States in its ninth Inter-American Conference in 1948. Okay, the same conference, it also adopted a declaration on the rights and duties of man, which is called as the American Declaration on the Rights and Duties of Man. Now, this declaration came before, even before the Universal Declaration on Human Rights. Okay, so this is a significant feature about this declaration. And at the same time, when the Universal Declaration just confines itself to the rights of the people, this American Declaration, as we can see from the name itself, it is the Declaration on the Rights and Duties of Man. So this declaration, unlike the Universal Declaration on Human Rights, it talks about the rights as well as the duties of man. Okay, so it also talks about duties of man, because we've already studied rights and duties go hand in hand. Okay, you cannot have a right without a corresponding duty. Okay, so it's generally essential that the rights, it's desirable that the corresponding duty, okay, uh, with regard to that particular right, or with regard to the rights, it's also stated. So the declaration, it talked about both the rights as well as the duties of man. If we see our own Constitution of India, there also we find that fundamental rights, that is enforceable. Okay, so fundamental rights has been provided under our Constitution. At the same time, we also find that there is a chapter in our Constitution which also talks about the duties of the citizens, which is called as the fundamental duties. Okay, so this Bogota Conference of 1948, it also requested the Inter-American Juridical Committee to prepare a statute for an American court to guarantee the rights of man. Okay, so with with the adoption of the Declaration on the Rights and Duties of Man, it also wanted the Bogota Conference. It also asked the Inter-American Juridical Committee to prepare a statute, okay, for establishing a American Court of Human Rights. Like we have the European Court of Human Rights that deals with the cases regarding violation of the rights and freedoms that have been given under the convention. The same way, the American Conference, it was talking about establishing an American court to guarantee the rights of man, and therefore it asked the juridical committee to prepare a statute towards this end. But the committee, instead of preparing the draft, it recommended to the council that first, it would be better that instead of preparing the draft first, uh, a convention on human rights is instead adopted. Okay, so instead of the statute being prepared first, the in committee the suggestion of the committee was that the convention on human rights, okay, that means the American Convention on Human Rights, should be first adopted. Okay, in 1959, okay, in a meeting of the consultation of foreign ministers, okay, uh, so this was in 1959. There was a meeting, okay, uh, between the foreign ministers, okay, who were the members of the Organization of American States. Now, in this meeting, okay, it was uh, the ministers, they came to the conclusion that a concrete action or some action has to be taken, okay, with regards to human rights, with regards to the promotion and protection of human rights, okay, in uh, by the American states also, okay, so that human rights can be protected and promoted in the American states. Okay, this was especially keeping in view the progress that Europe had specifically made, okay, in the context of human rights, because we know that human rights, the European Convention on Human Rights, it was adopted. Okay, so the Inter-American Commission on Human Rights. Okay, so with this action, with this objective in view, the action was taken, and it was to establish the Inter-American Commission on Human Rights. So after the establishment of the Inter-American Commission on Human Rights, the Juridical Council, it was again requested to draft the uh, prepare a draft of the convention, okay, and a statute for the Court of Human Rights. So the Juridical Council, it accordingly prepared a draft convention. Now, after this, the draft was considered at the this draft that was prepared by the Juridical Council. It was considered at the second special Inter-American Conference in Rio de Janeiro that took place in the year 1965. Okay, now this special, this second special Inter-American Conference that was held in Rio de Janeiro, it also took into consideration, it also produced two other drafts. Okay, one that was submitted by Chile and the other that was submitted by Uruguay. Now, the conference, it referred to all these drafts, okay, and then it gave it to the Council of the Organization of American States, okay, so that an acceptable draft could be evolved after the conference had the views of the Inter-American Commission on Human Rights. Okay, in the meanwhile, what happened was that two important developments took place. They were with regard to the Inter-American Commission. Now, the first development that took place was that Inter-American Commission was given the power to receive and consider individual complaints. Okay, so that means now individuals could come to the Inter-American Commission on Human Rights and submit individual applications to it with regard to the violation of certain basic rights, for example, right to life, right to religion, etc. Now, the second development was that the Inter-American Commission on Human Rights, it was formally recognized as a statutory organ of the Organization of American States. This happened in 1967. Okay. By the time 1968, by the year 1968, a draft convention had been prepared. Okay, and this uh, convention, this draft convention, it was adopted, at a special conference on human rights that took place at San Jose, Costa Rica. Okay, so this convention on human rights is also called as the Pact of San Jose. Okay, so this special conference on human rights that was called at San Jose, Costa Rica on 22 November 1969, it adopted this convention. Now, once adopted, this convention came into force of July 1978. So, this in brief is the drafting history of the American Convention on Human Rights. Now we come to the, we'll discuss the rights that are given in this convention. But before that, we will see the preamble of the convention. Now, the preamble of the convention, uh, we will discuss only few important paras of the the preamble. So one para, it states that the preamble, it recognizes that the essential rights of man are not derived from one's being a national of a certain state, but are based upon attributes of human personality. So this is, this here in this paragraph, the preamble is basically recognizing the principle of the the basic concept of human rights, that the essential rights of man, okay, they are inherent in nature, they are based upon the human personality, they are attributes of human personality, and therefore for its protection, they are not they are not dependent upon the government or the state. Okay, they are not dependent upon the state. Okay, so because in traditional international law, once we go back to our introductory classes, we discussed that in traditional international law, the individuals did not find a place. Okay, and therefore their human rights, you know uh, it was not recognized as such, because they were too dependent on the states, because they were not the prime players. Okay, they were not considered to be the subject of international law. It was only the states who were the prime players under international law. Okay, and the for the protection of their rights, the individuals were dependent upon the state. Okay, even if as the right of a national of a certain state, it has been violated, the by another state, okay, or by the by the citizens of another state, the particular individual whose right has been violated, he was not he was not in a position at that time to go and bring a suit against that particular state for compensation. Okay, it was only the state of which he was a citizen. Okay, that state was empowered to bring a suit against uh, another state for violation of the rights of its citizens. Okay, so but human rights, but the concept of human rights, it recognizes that human rights are basic and essential attributes of the human personality, and they are inherent in nature. Okay, the human rights are inherent, so therefore they are not dependent upon the government or the state first giving you human rights, and then also for its protection. Although of course the state plays an important role to promote and protect human rights, because it is the it is the personality which is which commands the resources and has the capacity to play a positive role, okay, in the promotion and protection of human rights. So the preamble, it recognizes that the essential rights of man are not derived from one's being a national of a certain state, but are based upon attributes of human personality. Okay, and that they therefore justify international protection in the form of a convention, reinforcing or complementing the protection provided by the domestic law of American states. Secondly, the another para of the preamble, it starts with that reiterating that in accordance with the UDHR, the ideal of free men enjoying freedom from fear and want can be achieved only if conditions are created whereby everyone may enjoy his economic, social, and cultural rights as well as his civil and political rights. So, in this paragraph, the preamble again recognizes one of the basic principles of uh, human rights. Okay, and that is that civil and political rights and economic, social, and cultural rights, they are both important. Okay, they are both equally important and they have to be given equal attention by the states. Okay, and equal importance. The state has to endeavor to promote and protect both types of human rights, economic, social, and cultural rights, as well as civil and political rights. Okay, uh, simultaneously. So it's not that if we go to the schools of human rights, okay, for example, the positivist school or the Marxist school, okay, for the Marxist school, it is the economic, social, and cultural rights that are more important first, because without that, the civil and political rights cannot be the higher, according to in their language, the higher rights of civil and political rights means civil and political rights, which are rights of a higher nature, they cannot be achieved without first attaining the basic and fundamental rights that are the economic, social, and cultural rights. So the we saw that in our discussion, we saw that the leftist leaning states, okay, they have a preference for economic, social, and cultural rights. The state gives more, importance to achieving the economic, social, and cultural rights rather than the civil and political rights. Okay, but we know that this distinction is, on the basis of nature. Of course, we can make a distinction, but this distinction that one type of right is more important than the other type of right, it's not right. Okay, it's not true. Okay, both types of rights are equally important, and the states are under a duty to achieve to focus on achieving both the rights together and to giving equal importance to both of them. Now, after that, we come to Article 1. So this is a non-discrimination clause. Okay. Now, basically, it says that the state parties have undertaken to respect the rights and freedoms recognized in this convention. Okay, the rights and freedoms that have been given under this convention, and then to ensure to all persons subject to their jurisdiction the free and full exercise of those rights and freedoms without any discrimination. So the states have undertaken that they have undertaken two things. First, that they will respect the rights and freedoms recognized in the convention. That means the state will not violate the rights of the citizens that have been given under this convention. Okay, and that it shall not discriminate in the exercise of those rights. Okay, on any ground. So non-discrimination on the part of the state has to be there. The state will practice non-discrimination when it comes to the exercise of those rights that have been given under this convention. This is similar to the non-discrimination clause that we find in the European Convention of Human Rights. And of course, non-discrimination, the principle of non-discrimination, again, it's a basic human rights. The non-discrimination in itself is a basic human right, because non-discrimination means that the state will not be arbitrary. Where discrimination is there, okay, except in cases where it is needed and is in pursuance to achieve a legitimate aim or objective, okay. Uh, Otherwise, discrimination, okay, uh, is basically, synonymous with arbitrariness. So if discrimination is being practiced by the state, it will give, it will violate the rights of the citizens, except in those situations or circumstances where the state is empowered to discriminate and where it is needed for the larger welfare of the society. Now, Article 2, it says that where the exercise of any rights or freedoms referred to in Article 1, that means the rights and freedoms that have been given under this convention. Okay, where these rights, okay, it is not already ensured by legislative or other provisions, the state parties undertake to adopt in accordance with their constitutional process and the provisions of this convention such legislative or other measures as may be necessary to give effect to those rights or freedoms. So this article, it basically is telling us that where the rights and freedoms that have been given under this convention, okay, they are not included under the domestic law of the state parties concerned. Okay, then whether it's in whether it's not included in their uh, any statutory law or constitutional law, etc. Okay, if they don't find a place in the domestic law of the state parties concerned, then the state parties will they have promised, they have undertaken, they have promised to take measures that are in accordance with their own constitutional process and with the provisions of this convention. Okay, that means just now we saw that even if the state is trying to give, suppose a state in accordance with its own constitutional procedure, okay, it enacts a law that gives effect to the rights that have been provided in this convention, but then it discriminates. Okay, and that discrimination is arbitrary. It discriminates between two communities. Okay, to one community it provides that right, and the other community it is not providing the right. So this, even if it is there, if it has passed in accordance with its own constitutional process, it is not in accordance with the provisions of this convention, and therefore this will not be valid. So it has to be in accordance with its own constitutional process and the provisions of this convention. Okay, and you know measures in the nature of legislative enactment or any other measure that may be necessary to give effect to those rights or freedoms, it will be taken, and the rights and freedoms will be incorporated or incorporated under the domestic law. Now, some of the rights that have been provided in the convention under the convention are civil and political rights. First, we will deal with the civil and political rights. So, civil and political rights in the nature of right to judicial personality, right to life, right to human treatment, freedom from slavery and involuntary servitude, right to personal freedom, fair trial, ex post facto laws, okay, a right to compensation for miscarriage of justice, right to privacy, right to family, a right to name, etc. All these rights have been provided. So, right to judicial protection, right to participate in government. Okay, so these basically are civil and political rights that have been provided under the convention. Now, if we see, uh, you know, the rights that have been provided in the convention, if we see the content of these rights, we find that uh, generally uh, it's not the case that the convention, it covers the rights in a very detailed manner. Okay, but the American Convention on Human Rights, it's very exceptional in this regard. Means it covers even the basic principles, and that are generally not covered, and you will not find it covered in other conventions, etc. Okay, it goes to great lengths to cover even the basic principles and the associated or elite principles with regard to the main right that is there. Okay, so For example, we will deal with certain rights, okay, under the convention uh, understand this point. Now, for example, Article 4, right to life. So, we have already done from UDHR to ICCPR, okay, and then to the European Convention, we have done right to life. And in our discussion, I continuously referred to the Indian Constitution also. So, you know the content of right to life. Okay, we have a basic understanding. Now, but we all wherever we have discussed the right to life, we don't find that, for example, if we see para 2 of article 4, it says that in countries that have not abolished the death penalty, it may be imposed only for the most serious crimes and pursuant to a final judgment rendered by a competent court. So now we generally don't find a provision relating to death penalty, okay, in such detailed manner, okay, under the right to life, okay. So but here we see that para 2 is telling us that in countries where death penalty or capital punishment is still being given, okay, there, uh, it can only be imposed in the most serious crimes. So what it's trying to say is that death penalty cannot be given as a normal punishment, okay, or it cannot be imposed as a matter of a general rule, okay. Only in the most serious crimes and pursuant to a final judgment rendered by a competent court can death penalty be given. So you can understand this in the same way that, uh, by comparing this with our own constitutional jurisprudence, whereby the Supreme Court of India has told that death penalty can only be given in the rarest of rare cases, okay. It's not in every case that, or every now and then that, the death penalty can be given, okay. Only in the most only the rarest of rare cases, okay, this death penalty has to be or can be given, okay. Then para 3, it says that the death penalty shall not be re-established in the states that have abolished it. Now, this para 3 that we see before us, we find that it goes even beyond the regular, uh, you know, the regular provisions that we generally find or we will find, with regard to death penalty. Here, this para, it goes one step forward. Rather than saying that death penalty has to be abolished, it says that in those states where it has already been abolished, okay, it cannot be re-established, okay. So for example, in a state X, we have we don't have in state X, we don't have death penalty as a punishment today. So tomorrow, state X cannot have death penalty, okay, as a form of punishment. So this is a very unique provision in under the American Convention on Human Rights relating to death penalty. Okay, whereby the states which have already abolished death penalty, states which don't have death penalty, they are, mandated that they cannot, uh, you know, have death penalty in future also. They cannot restore death penalty as a form of punishment. They are prohibited from doing so. Now again, para 4, it says that in no case shall capital punishment be inflicted for political offenses or related common crimes. So this, this para, it prohibits death penalty, okay, as a form of punishment in those cases which relate to political offenses or crimes of uh, the same nature. Okay, so in those cases also, death penalty cannot be given. Now, this may have to do with the. This may also have to do with the particular circumstances. That the or situations that many of the American countries, they had, for example, regime change or dictatorship, etc. So that is why, where in these type of situations, political revenge, okay, is very often seen. Okay, one you know. One party or a person coming to power, okay, he tries to uh, get political revenge, okay, after coming into power from the other party that has lost the power, okay, or that is the political party or the person who is not in power anymore. So this these kind of situations they were they generally existed in the American states, and therefore this provision might have to do with with that factual keeping in view that factual background. Okay, now para 5, it also says that death penalty cannot be imposed where the convicted person, okay, is under 18 years of age, that means he's a minor, or he's over 70 years of age. So age is also a factor, okay, which has to be taken into account when death penalty is being imposed. So it cannot be imposed on minors, and it shall not also be imposed on people who are over 70 years of age, nor shall it be applied to pregnant women. So, of course, this we have, there is a case of our own Supreme Court, whereby the Supreme Court, it changed the death penalty of a particular convict to life imprisonment, because at the time of the conviction she was pregnant. Okay, so taking a humane view of the situation, and especially this particular situation where a female convict is pregnant, okay, the Supreme Court decided that the death penalty is not the appropriate punishment or cannot be handed over in such a case, and rather it converted it into life imprisonment. So now, para 6, it says that every person condemned to death shall have the right to apply for amnesty, pardon, or commutation of sentence, which may be granted in all cases. Now, this also you can relate to the position of law that exists under our own constitution, under our own domestic jurisprudence, our own constitutional jurisprudence. Okay, wherein person who has been condemned to death, he has a right to to approach even the president of India for pardon. Okay, or he has a right to appeal to the court also. So this right also is expressly given under the American Convention on Human Rights. Next we see is Article 5, which relates to human treatment. Okay, it talks about the right to human treatment. Now, in this also we find that para 4, it says that accused persons shall, save in exceptional circumstances, be segregated from convicted persons. This is a principle of policy, and this is basically followed. This is basically followed almost in all countries, but you don't find it, this provision, you don't find this particular provision to existing in a convention. Okay, we generally don't find it. So, but here we find that this has been again expressly incorporated in the convention itself, into the text of the convention. Okay, and then again, para 5 talks about the separation of minors. Okay, when a minor in conflict with law and is in conflict with law and criminal proceedings are initiated against it. Okay, then it is telling that they have to be separated from the adults and brought before a specialized tribunals. So we have for minors, uh, they are called juvenile. Okay, so for juveniles we have the juvenile tribunals. Okay, which are separate. Okay, which deal with only with the minors who, or with the cases of juveniles or the minors who are in conflict with law. Okay, so this also you don't find expressly incorporated into the conventions, but we see that the convention is in some aspects very detailed. Okay, and para 6 again, it says that punishment consisting of deprivation of liberty shall have as an essential aim the reform and social readaptation of the prisoners. So when we come to punishments in the criminal law, there are two theories of punishment, two main theories. One is the deterrence theory, and the other is the reformist theory. Deterrence theory basically says that you have to, the aim of the punishment is to make an example of the person, okay, who is punished, to set an example in front of others, okay, to give a message to others not to indulge in the same conduct, okay, to deter other people who might indulge in the same conduct, who might commit the crime. Okay, so it is to instill fear, okay, in the minds of the people. So so that it, the punishment can act as, has a can have a deterrent effect. Okay, the other is the reformation theory. Now reformation basically says that the aim of punishment is not to have a deterrent effect or not to punish the person. Okay, but it is to uh, to reform the individual person who is in conflict with law. Okay, so that he can be incorporated back into the society as a responsible member. Okay, so this para 6, it takes into account and advocates the reformist theory of punishment. Then we have Article 8, which tells about right to fair trial. So apart from the basic, basic principles of criminal law, such as right to be presumed innocent until and unless proved otherwise. Okay, it also we see that para 2A, it talks about the right of the accused to be assisted without charge by a translator or interpreter if he does not understand or does not speak the language of the tribunal tribunal or court. Now, this is also a fundamental or basic rule of criminal procedure, okay, or criminal law, whereby a person, if he cannot understand, okay, the proceedings, or he cannot understand the charge against him because he speaks in a different language, or he's not acquainted with the language of the court, okay, or the authorities, then it is their duty to make an interpretation of the same and to inform him so that he knows, so that he's aware of the proceedings that are taking place against him. Okay, and this article, it further says that, talks about in clause E, it talks about the inalienable right to be assisted by counsel provided by the state. aid or not as the domestic law provides, if the accused does not defend himself personally or engages own counsel within the time period established by law. So again, this is of course in our own constitutional jurisprudence. This, by virtue of the Supreme Court judgment, this has emerged to be a fundamental rights of the citizens, the right to be provided legal aid, isn't it? But we find that uh, this right has been expressly, covered by the convention. This has been expressly incorporated into the text of the convention. Then again, other fundamental and basic rules of criminal law, they have been incorporated into the convention, which we don't find, uh, you know, as such. We don't find it. They are fundamental and basic, but we will not find it uh, under the inside the text of the convention itself. Okay, as forming a part of the convention. But here the convention is very detailed in this aspect. So we find that the right of defense to examine witnesses, which is also called as cross examination. Okay, so the right to cross examine, the right not to be compelled to be a witness against himself or to plead guilty, again a basic fundamental human right. Okay, and this is also there under our own constitution of India. Okay, uh, the right against self-incrimination, this is called the right against self-incrimination, and the right to appeal the judgment to a higher court, and the confessions of guilt by the accused shall be valid only if it is made without coercion of any kind. So para 3 it says that a confession of guilt by the accused shall be valid only if it is made without coercion of any kind. So again, this is a basic principle of criminal law, whereby confession itself to the police officers, it's not valid. Okay, and apart from them, confession also has to be without coercion. So this is a fundamental basic principle, but then again, we don't find it in the we don't find it in the text of the convention, but the American Convention has incorporated these the basic principles, okay, inside in its text. Now, as we found in ICCPR, as we found in ECHR, okay, all the rights and freedoms, of course, there is no right and freedom that is absolute, and there, of course, the states being the prime players, and the states, being the main entity or the personality which is, which has obligations under the convention. Okay, uh, so if there is a situation which, of course, threatens the life of the state itself, okay, then these rights that are given in the convention, they can be, of course, suspended. It's the same thing. They can be, the state is empowered to derogate from the mandate of the convention. It was the same thing we found in ICCPR and the ECHR. Okay, so Article 27, it says, Article 27 para 1, it says that the rights and freedoms may be suspended in times of war, public danger, or other emergency. Okay, and in this kind of in these situations, in this kind of a situation, a state may take measures derogating from its obligations to the extent that for the period of time is strictly required by the exigencies of the situation, provided that such measures are not inconsistent with other obligations under international law and do not involve discrimination on the ground race, color, sex, language, religion, or social origin. So it has almost the exact same content as we found under ICCPR, okay, dealing with emergency situations, and under ECHR. Now, of course, we know that even in cases of emergency, okay, or situations which or circumstances which threaten the life of the state itself, Okay, even in those situations, the state cannot derogate from the mandate of certain fundamental rights. Okay, for example, right to life. Okay, even under our own constitution of India, we know it very well that two articles, okay, Article 20 and Article 21, they are not suspended even in times of emergency. Okay, so and this we saw, even this was the same position under ICCPR and ECHR also. Okay, wherein it was mandated that even in the times of emergency, the parties are not authorized to derogate from certain rights that have been stated in those conventions. Okay, so here also Article 27 para 2, it provides that the state parties uh, under this convention, they are not authorized to suspend the following articles, that is Article 3, Article 4, which relates to right to life, Article 5, which relates to right to human treatment, Article 6, which relates to freedom from slavery. Of course, we already know that prohibition of slavery has become, is recognized as a us cogens norms also now. Okay. Article 9, freedom from ex post facto laws. Article 12, freedom of conscience and religion. Article 17, rights of the family. Article 18, right to name. Article 19, rights of the child. Article 20, right to nationality. Article 23, right to participate in government, or the judicial guarantees essential for the protection of such rights. So the state, even in times of emergency, cannot derogate these fundamental rights and freedoms. Now, this under para 3, the article, it mandates that the state which is availing the right of derogation, okay, under Article 27, it will immediately inform of such derogation to the Secretary General of the Organization of American States. Okay, and it shall inform the following three things. First, the provisions, the application of which it has suspended. Okay, so it has to inform those rights, okay, which it intends to, which it is derogating from. Okay, and second, it has to inform the reasons that have given rise to this suspension. And third, it has to inform the date set for termination of such suspension. That means the date on which the said suspension will get over. Okay, the suspension of the rights will get over. Next, we come to the economic, social, and cultural rights. So here we see that Article 26, it says that progressive, it talks about progressive development. Now we already know when we were studying the universe, the ECHR, ECHR, I'm talking ICESCR. Okay, then we discussed that, of course, when it comes to um, economic, social, and cultural rights, okay, it is uh, it is conceived that the states will take measures to progressively to achieve progressive development of these rights. Okay, rights which are in the nature of economic, social, and cultural rights. Okay, this is why, because it was uh, it was realized that because of the very nature of these rights, it won't be possible for many states to, okay, to achieve uh, these rights in uh, immediately. Okay, it's not possible to achieve these rights immediately. The achievement of these rights will, because of their very nature, okay, it will take time. It will take time. So the states have to continuously endeavor to achieve these rights. Okay, and therefore these rights have to be progressively achieved. So there has to be a progressive development when it comes to the achievement of these rights on the part of the states. So Article 26 says that the state parties undertake to adopt measures both internally and through international cooperation. So we also, in our introductory classes, okay, when we were discussing UN, and we were discussing when we were discussing the first generation, second generation, third generation of rights, etc., and we discussed that the achievement of these rights, economic, social, and cultural rights, especially, or they require, or achievement of human rights in general, it requires not only the will of the state concerned, okay, by framing the statutory laws, or taking legislative measures, for example, or framing policies, etc., towards the achievement of these rights, but it is also necessary that there is international cooperation, okay, among the states, so that these rights can be achieved. Okay, so the state parties have undertaken to adopt measures both internally and through international cooperation, especially those of an economic and technical nature. Okay, with a view to progressively, by legislation or other appropriate means, the full realization of the to achieve progressively the full realization of the rights implicit in the economic, social, educational, scientific, and cultural standards set forth in the Charter of the Organization of American States. So, this is, a brief discussion about the rights that have been given under the convention, both civil and political rights, and also a brief discussion about the drafting history. Okay, in the next session, we will start from the implementation mechanism under the convention. Okay, so we will be taking up the implementation mechanism in the next session. Thank you.